My name is Liz Novak. I'm the Senior Director of Marketing and Advocacy, as well as Editor-in-Chief for IAPD. Thank you for joining us for today's e-training webinar on Prop 65, presented by attorney Carol Brophy and toxicologist Mike Easter. During the presentation, you may submit questions in the Questions tab on your webinar toolbar, and we will answer your questions at the conclusion of the presentation. Following the webinar, you will receive a link to a survey. Once you have completed the survey, there will be a link to download the presentation slides. You will also receive a recording of today's webinar. Feel free to share the recording and slides with others in your office. First, let me introduce the speakers that we have on the line with you. Carol Brophy is a seasoned litigator representing clients in environmental law, administrative law, and state and federal litigation. Brophy's background as both an engineer and an environmental assessor enables her to apply these skills not only to the legal aspects of compliance, but the scientific and technical aspects as well. She has extensive experience developing cost-effective compliance solutions for manufacturers and chemical processors. Mike Easter is a certified hazardous materials manager. He has more than 20 years of experience. Easter performs evaluation of Prop 65 listed chemicals, among other services. I would now like to turn the presentation over to Carol and Mike.
Thank you very much, Liz. Can you advance the slides, please? On the screen, you'll see an agenda. We are going to have a general introduction on how California is using Proposition 65 to regulate the world, a brief overview of Proposition 65, stated warnings for the stated reasons by the agency for the new warning requirements, a brief overview of the new warning requirements and regulations, and we'll address in more detail, and the bulk of our program will be the realities of compliance, and we hope to get into best compliance practices. And we will also have a question and answer period at the end. If you would write your questions down, we're going to ask Liz to be the moderator of the questions that she gets so that we can try to triage them and address the ones that are the most important or the most common as we go forward. Next slide, please. Proposition 65 establishes a list of chemicals known to the state of California to cause cancer and reproductive toxicity. There are two provisions. First, it prohibits discharges into a source of drinking water, but unless you're located in California, you probably are not going to be too concerned with the drinking water provision. If you are located in the state of California, then you may need to have some consulting, and we can assist you with that, but it will not be the topic of today's webinar. It also requires warnings, and this is the topic of today's warnings. In fact, we're going to just be speaking about the consumer product warnings. There are several types of warnings, but this webinar will focus on consumer product warnings and how to provide warnings if you are a manufacturer of products or ingredients or components that go into consumer products. We're also going to advise you how you can possibly avoid warnings based on testing and exposure assessments. Mike Easter will be highlighting and discussing the testing and the exposure assessments portions. Proposition 65 enforcement is a real problem worldwide. Anyone who does business in California or whose product ends up in California can be sued. And private enforcers are able to sue in the public interest with no injury requirement at all. In other words, they can act as a private attorney general, and they get 25% of any civil penalty that they can either negotiate from you or that they can get the court to award if it goes to litigation. The big reason that Proposition 65 is such a problem worldwide for business is because the enforcers get reasonable attorney's fees and costs from defendants. This means their law firms are basically able to use the threat of litigation in order to negotiate out of court or even in court settlements from defendants where tens of thousands, sometimes over $100,000 in attorney's fees are paid by the defendant to the bounty hunter or the plaintiff's lawyers. All of these things coalesce to make Proposition 65 a real threat to businesses worldwide. Next slide, please. This is the wording of the text of the warning provision. I'll read it briefly. No person in the course of doing business shall knowingly and intentionally expose any individual to a chemical known to the state to cause cancer or reproductive toxicity without first giving a clear and reasonable warning to such individual, except as provided in Section 25249.10. I have provided to Liz an overview of Proposition 65. It's a white paper. Liz, did you receive that?
Yes, Carol, I did get that, and that will be posted on our website, and it's also among the materials that people will be able to download after they fill out the survey.
Great. I would encourage everyone to fill out the survey so you can get the white paper. The white paper is a list. It's basically an overview of the law. It's just an overview, but it goes into it in a lot more detail than we are able to do in this short webinar today. Next slide, please. These are the reasons that the state of California gave when they decided to update these warnings. Let me advise that warning requirements have actually been in place since emergency regulations were adopted as long ago as 1987. However, 30 years after the fact, the state of California decided that they wanted new regulations on how to provide warnings. The only sections that were changed are the text of the warning, and there is one new requirement, major new requirement for delivery of the warning, and that is that internet warnings are required for retailers that are selling products that are shipped to California. So do not think that this is a brand new requirement. This is just a change in the text of that the state deems clear and reasonable, and that will allow you to not be sued if you use text that is subject to the safe harbor warning provision. The changes for the text and the reasons for making the change is the state determined that the existing warnings, the ones that have been given for 30 years, were not clear enough because it did not identify with specificity the chemical that the product would cause the exposure for. So The new regs require at least one chemical to be identified in the warning. Also, the state determined that there was no way that people could get information and that people were confused. So in order to get more information from the state's point of view, the new warning requires having the Proposition 65 website added to the text. In theory, consumers can go to the state's website, look at the link, and then find more information about the chemical at issue and about the exposure at issue. Additionally, it determined that they need something to call out and make these warnings more noticeable. Therefore, they put a yellow triangle with an exclamation point as a symbol, and the thought is this keeps the defendants or the businesses from burying the warning in a long paragraph. They have to set it aside, and they have to have this symbol on it, which in theory will cause the consumer to pay more attention to the warning. Another major reason that the warnings change was deemed necessary is that everybody in the world keeps putting just warnings, slapping them on everything. And the idea was by having to name a chemical and doing other changes, this would prevent prophylactic warning or overwarning. I bring to your attention the reason everyone just throws the warnings on everything is that if you have a warning, a bounty hunter cannot sue you. But if you do not have a warning and the bounty hunter finds a detectable level of a chemical in your product, you can be sued and then be forced to defend that decision not to warn. As a result, people just put it on everything if there is a reasonable possibility that there might be a chemical exposure caused by the product, and the state absolutely positively wants to stop this practice. So that's why they decided, a major reason they decided to change the warning requirements. Another announced purpose was to push the warning requirement up the supply chain to the manufacturers and importers from the retailers that are doing business in California. And this is throughout these new warnings and the statement of reasons. There are provisions to carve out and try to let the retailers who sell products in California get out of being the party that is going to be sued and instead shift that burden back to the supplier, the distributor, the manufacturer of the products. And the last one is already covered. There are express provisions, as we'll see, about how retailers can actually avoid responsibility in some circumstances. Next slide, please. And this is a summary of what I said. I won't go into it for time reason. The new regs go into effect on August 30th. The new warnings on all products manufactured on or after that date. Inventory, things you may have in your warehouse right now are grandfathered in. You do not need to put the new warning on them, but you have, if they require a warning, you should have at least the old warning on them. So the grandfathering does not apply if you've never provided warnings for products that needed them. This only says that the old warnings can be used until the product is manufactured on or after August 30th. Then the date of manufacturing controls, you will have to put the new warning on at that time. Next slide, please. And these are examples of the warnings, the long form warning. There is in the white paper that I am providing to you a more discussion about this. They're a little hard to get right for each product. Sometimes you need to actually think about what's in each product and tailor the warning. That was intended. The idea is that California wants each and every product evaluated and some thought given, and the warning tailored for that particular type of product, if not the specific SKU of the product. Food warnings, I'm also just calling this out, although I doubt if many of you folks online actually manufacture foods. I'm sure you do manufacture plastics or distribute plastics that are used as food contact surfaces and also food packaging. So it's wise to be able to understand that there are specific types of warnings that are required for foods, and that's a little different, and your customers may need to be understanding of this as well. Next slide, please. There is a short form of warnings. These warnings are only used on the package. They are not able to be posted on signs that would go up, be posted at retail, or they are not able to be used for internet sales. Long form only for those particular types of warning. There's some nuances to that interpretation, but as a general rule, 99.9%, you can only use the short form on the package. In theory, and by intent, California did not want the short form to be used except where the package is so tiny you can't get the longer text of the warning. For example, on eye drops, a little tiny thing, or medicines or cosmetics that are little small packages of eyeshadow or something where they just can't get that warning on a larger label. What is happening, however, is that everyone has figured out that at this time, there is nothing in the text of the regulation to prevent people from using the short form on everything. Something that I'm going to ask Mike to chime in now. We believe we may be going to take action to clarify and adopt amendments to this reg that would limit the scope of the short form warning. Mike, would you like to report on your conversations with the agency in this issue?
Sure. And can you hear me okay on this? Can you hear me?
Yes, Mike, you're coming through loud and clear. Thanks.
Okay, I'm sorry. Thank you. Yes, I had some communications with the Office of Legal Counsel on this very topic as to whether or not the short form warnings, if they can be used exclusively, and what their thoughts were on them. And they expressed some concern that it may have the potential to be used by a lot of different industries, and the concern is that it will overwhelm the other warnings and defeat the entire purpose of having these more definitive warnings. And so there was some thought being given on reopening the warning requirement or the warning regulations pending some early review of how prevalent the short form warnings are. And so to Carol's point, it seems likely that if things are going the way that they seem to be, is that there'll be some additional action by OHIA to revise and limit the use of these short form warnings consistent with other administrative issue or administrative flexibility, so much as Carol had mentioned on the short or the small packaging and small items. Go ahead, Carol.
So next slide, please. I give advice to people that say, oh, I want to put the short form on my product because I don't want to test. I advise them, if they're reasonably certain that they know that there's a chemical in the product, they should avoid using the short form warning. Let me give you an example. You manufacture some kind of PVC or plastic product. Well, you may be reasonably certain there is a phthalate in that. Phthalates, there are 7 listed phthalates. It is a family of chemicals, as you know, but some of the phthalates are carcinogens, some of the phthalates are reproductive toxins, some are both. What I generally point out is when you do a test, you do something called a phthalate panel to determine what is in the product, you're likely to get detectable levels of more than one of these chemicals. If you reasonably believe you're going to get a detectable level of, say, DEHP, which is really prevalent, and it's almost impossible to buy a pure phthalate of any one of these. It based on the way they're just manufactured, that we often find that there are residuals of some of the other phthalates in it. Just, if you're reasonably certain, use DEHP as your named chemical because it's both a carcinogen and a reproductive toxin, and that will allow you to use the longer form. It gets you out of being one of those parties that the state of California says, oh my gosh, look, there's a big sheet of 4x4 of rigid plastic, and they've got just a safe harbor short form warning on it. We're trying to avoid putting those warnings on large items that have large real estate where a large warning could be provided. And this will also, we think, in the long run, help everyone so that the state doesn't decide to remove the ability to use the short form warning entirely. And it doesn't harm anyone in the plastic industry because there are so many listed things that you usually can be reasonably certain are going to be in your product. So again, that's a general statement of general advice. You need to look at your individual products in order to make the actual decision on what to do. Internet and catalog warnings are among the new requirements in the new regs. There are a lot of nuanced issues that, you know, I understand I'm going to be speaking to your meeting, your government relations convention meeting, and we can go into a lot of these in more detail at that time. But you may find that even that you have an internet presence, even if you're selling and distributing products to business, bounty hunters have been known to find these B2B sites, order products from them, and then go ahead and sue them under various theories. To avoid that happening, it's probably not a bad idea, even on your B2B catalogs and internet sites, to think of some way that you can provide a warning if you're going to be shipping products to California. And this is something that probably needs a case-by-case counseling. Many of you may not have this issue at all, so we decided not to go into it in too much detail today. But depending on questions and interest, we can do so at the October 4th meeting. In theory and in practice, according to the state, the warnings have to be given prior to checkout. They need to be on the product display page with at least the word warning, or they can be on the checkout page if the warning is clearly associated with the actual product providing the warning. The catalog warning is the same. The warning needs to be on the product display page. If you have internet or telephone order, you can provide that warning once the caller says they're going to want this product shipped to California. You can provide it verbally, or you can provide it by an internet order, some mechanism in your programming so that that warning gets to the California purchaser and not to people in the rest of the world. Next slide, please. Take a moment to talk about the requirements of Proposition 65 that inure based on where you fit in the supply chain. And as an overview to that, California recognizes that they cannot force suppliers of components or suppliers of industrial use only products to comply with Proposition 65 if the sales of these products and the manufacturing of these products occurs out of state, out of the country, and they are shipped to another industrial user or manufacturer that also is out of California. So California instead has figured out ways that they can hold carrots over the head of companies that sell at retail in California to force them or strongly recommend that they impose liability by contract. In other words, if you do business and sell to a company who manufactures something that is then sold in California, you're likely to find in your purchase order, in the contracts for sale, in your requirements, an obligation to indemnify the manufacturer that anything that you sell to them does not require a Proposition 65 warning. It gets nuanced because sometimes you're selling raw materials and the warnings and the information usually goes on SCSs for those cases. Or you may be selling a product that they in some way change or they repackage and then sell to California. But in any of these range of possibilities, there's likely now and in the next few months and years, more and more Proposition 65 compliance, reformulation standards, certifications that are going to be required, not because Proposition 65 requires that suppliers do this, but because the businesses that do sell products and manufacture products going into California are looking desperately for ways to stop and triage these bounty hunter lawsuits and prevent liability. Something we didn't say earlier, but I think we should say now, there are literally thousands of these bounty hunter suits, these notices of intent to sue. Millions of dollars are collected every year from businesses, almost all of which go to pay are out-of-court settlements that are basically nuisance lawsuits. They range from the very cheapest ones to get out of to 10 grand to over $100,000. Just payoffs to the plaintiffs to stop the bleeding and stop the litigation. So it's a very real threat, especially to retailers and folks that are selling consumer products into the state. people with real focus in the state will get 10, 20, I've seen as high as 25. I have one company right now that already this year has over 25 notices of intent to sue, and they're a retailer. So these companies are desperate to push the liability back, and they are encouraged to do so by the state of California. For this reason, as we move into this discussion of compliance and mechanisms, I'm going to refer to two kinds of regulated entities. First are the directly regulated entities. These are folks that the law can reach out and grab directly in a litigation. And those are folks like retailers, the manufacturer of a product, and importer of a finished product, the distributor of a product, or a licensor. If you hold a brand name and you license it to a third party to use on another product, you can be sued directly just by dint of owning the brand name. You are deemed to be a manufacturer. You are deemed to be subject to California law. But these are pretty much common sense people. Now, the indirect folks, of which I imagine a number of IAPD companies are indirectly responsible. These are folks that are responsible by indemnity agreements and contracts for purchasing. Foreign manufacturers, distributors, importers, companies with fewer than 10 employees, and licensees, ingredient and component suppliers. This is a wide range of people worldwide. Sometimes it's important to note that a company will be both directly responsible for some products and will be an indirectly responsible party on some of its other products that it sells. Next slide, please. The direct responsibility falls to folks that supply a consumer product or a service. The manufacturer of the product, the importer, in other words, if you manufacture something in a foreign country or you have a third party manufacture it, say in China, and you cause it to be imported into the United States and it subsequently finds its way into California, you are directly responsible as if you actually made it in your own plant in the US. A distributor, if you buy product from a third party and then you distribute it, for example, let's take that sheet of plastic that we talked about, or a tube, you say something that's used for irrigation systems, or some kind of plastic sheathing, and you distribute that to someone else who then sells that, and you distribute it, say, to Home Depot, or you distribute it to someone else, and you act as a broker, and then that person distributes it to Home Depot for sale in California. You are going to be in this train of commerce. You reasonably are held to know that it would end up in California and you could be sued directly. A licensor, again, if you have the brand name that you own. Now, the retailer, we gave a retailer seminar at Steptoe, and it is, if you are interested in knowing about the nuances of being a retailer, we have left that webinar online, and if you will send to me or to Liz, I will make sure that you can get a link so you can go and listen to the retailer webinar. It was quite lengthy, and there are a lot of nuanced issues for retailers. I'm just going to outline the requirements briefly here. retailers can either be responsible for providing warnings or not responsible. I'll start with not responsible first. They are not responsible if they sell a third party's products and they do not have actual knowledge that the chemical at issue is in the product or could cause an exposure. In other words, if Home Depot sells a piece of rigid plastic, if they did not get a notice of intent to sue and they says this rigid plastic has BPA, or this rigid plastic has styrene residuals, or this rigid plastic has some other listed chemical, if they take the product off market or they put stickers or signs up and immediately within 5 days, then they are not deemed to be a responsible party and can't be sued. So many retailers are doing everything they can to make sure that they don't have to become a responsible party. However, they are going to be a responsible party under any one of 5 circumstances. If they own the brand, in other words, it's a house brand, you manufacture plastic that is sold under the Home Depot brand, and you manufacture it for them, but they slap their name on it, they're going to be liable for the warning. If the retailer knowingly introduced the chemical, probably not going to have anything to do with products you sell, but for example, a retailer sells coffee and they give out free samples at Costco. Well, everyone knows that coffee, when you brew it, contains acrylamide, and that retailer, by brewing that coffee, is now responsible by adding that chemical, and they've got to provide warnings when they give out those samples. That's just one example of how that might happen. If the retailer defaced the warning by, for example, putting his sticker on top of your warning on the label, he's going to be responsible. If the retailer is notified by the manufacturer and the manufacturer failed to post the warning signs or take action, the retailer can be responsible. And finally, if they have actual knowledge of the exposure and the manufacturer has fewer than 10 employees, or the manufacturer does not have an agent for service of process in California, then the retailer can be sued and is responsible. So these are the carrots that have been given to the retailer, and as you can see, one of the ways that they're trying to avoid being responsible for getting those 25 to 30 notices a year and having to pay, several $100,000 of what they consider to be blackmail to get out of them, retailers are taking actions by pushing these obligations back up the supply chain. Next, please. Next slide, please. Liz, can you hear me?
Yes, hi Carol. Are we looking at overview of Prop 65 compliance requirements, indirect responsible by indemnity?
Yeah, this is fine. This is fine. It changed. I didn't notice. My apologies, everyone. Again, there are different compliance requirements for whether you're an indirect party responsible by indemnity or whether you are a direct party. So let's look at indirect responsible by indemnity, where the finished product is actually being sold. This is different from the indirect, where you are selling a component or an ingredient in a product. Foreign manufacturers, distributors, and importers, and companies with fewer than 10 employees and licensees are only going to be able to be sued if, well, they aren't going to be able to be sued directly. They can be countersued, or they can be tendered indemnity demands by the retailer or the parties to the suit, and they would have to cover the cost of settlement, or they could be cross-complaint against in the action, which occurs very rarely. Ingredient component and suppliers can usually satisfy their obligation by using an SDS to provide information to the company that they sell their products to. And bottom line is they can use Section 15 in the SDS to provide information about California's Proposition 65 and communicate with their customers. Ingredient manufacturers should also consider offering cleaner product as alternatives. For example, if you sell various grades of plastic or various grades of chemicals, and you can get rid of some of the contaminants that may be in those products, such that when they are used by your customers, the requirement for warning can basically fall away and not be required, you can charge more for some of those higher grade and reformulated products, provided that you can provide certifications and you can advise and market these to your customers in a way that your customer can use those products to avoid having to warn themselves. And in a minute, I'm going to ask Mike to give a couple of examples that we found in the plastic industry for that sort of thing. This is another point that is very important for those that sell industrial use only products. And there's not a lot of time in this particular seminar, but I will address this whole topic at more length on October 4th. OSHA actually, if you sell an industrial use product and you are located out of state, OSHA preempts California laws unless federal OSHA has approved them. California has its own OSHA program, but and it is approved by the federal OSHA. But as a condition of approving the California Hazard Communication Plan, California cannot enforce Proposition 65 against out-of-state manufacturers of industrial use products. Let me say that again. California cannot, and bounty hunters cannot, enforce Proposition 65 against a manufacturer of an industrial use product directly. They can't do it. We can give you some examples and talk about ways. This is very nuanced. But if you sell products that never get sold at Home Depot and never get sold directly to consumers in California, you should not be subject to lawsuits by these bounty hunters. And if you do get such a notice, we're likely to be able to get you off quickly. Okay. Caution. If the product is sold to consumers or any conceivable way, like suppose you sell industrial use products, but you sell them through, say, jet.com, which is it used to be a B2B website. Many of these B2B websites do allow consumers to sell and buy them. And we found that if you do sell through these third-party B2B websites, you're likely going to lose all that protection because these will not be deemed to be business-to-business transaction, but rather business-to-consumer reaction by dint of going through some of these these websites that sell directly to consumers. Next slide, please. And again, California retailers are requiring vendors and suppliers to accept liability for these compliance by these vendor indemnities, and also some retailers are refusing to accept products with warnings and will require reformulation. How do you deal with this? Well, regardless of where you are in the supply chain, distributors and importers should require upstream compliance by their manufacturers, the people that provide you with your ingredients. You need to evaluate how those products are used, and based on your own analysis of how your products are being used by your customers, you may need to consider reformulation, product purity, creating different grades of products and certifications that you offer to others. We're seeing a lot of increased demands for reformulation and testing certificates. I would suggest you might make this a lemonade and look for ways that you can meet those needs at a premium price and expand your market. Manufacturers, if you do manufacturing of even a component part, or if you're doing manufacturing of a finished product, we recommend a compliance audit. As Mike will be talking about, you should evaluate your components, your ingredient sources, set specifications, and look at your regulatory options, which we will discuss next. If you are an ingredient and a component supplier, we also, again, recommend a compliance audit, evaluating reformulation options, setting specification, and looking at your regulatory options. Next slide, please. This is the meat of this seminar. Have a Proposition 65 compliance program wherever in the stream of commerce you are located. Have a written procedure. Designate a responsible individual and include a team of people that are going to be part of your solution. Now, you need to include all relevant functions: your purchasing, your manufacturing, your QA, QC, your operations, and your regulatory folks. And you need to integrate Proposition 65 compliance into the way you do business. You know, it's not hard. It really just takes becoming aware of what sort of chemicals can be in your products, and then thinking of ways that you can reduce those that are not actual components of your product, but maybe there as an unintended consequence. And to do that, you need the help of others in your organizations to figure out the smartest and best ways to handle that. And once you develop this kind of overview and compliance plan, you'd be surprised as to how easy it is to train folks in your company and to integrate it into the way you're doing business, so that the cost is pretty negligible, and you may actually find you're meeting your customers' needs better, and you are reducing your risk and liability at the same time. So do a Proposition 65 audit. Part of that audit, which Mike will talk to next, is know what products contain listed chemicals, which are found in your ingredients, which are formed during your manufacturing. What is found in your packaging? Don't forget your packaging. Determine whether you can reformulate or otherwise avoid warning. You may need to do an exposure assessment. They're really not that difficult, and you can do them by category of products. And then provide warnings if necessary. And the next big bullet is have a plan for working with others in the stream of commerce, both those that are above you, supplying you with ingredients, and those below you that are distributing and selling your particular products. Next slide, please. And Mike is going to give you the next section, which talks about exposure assessments and his perspective on compliance audits. Mike?
Thank you, Carol. And as we go through these next couple of slides, I'd like to have you think about it from your product perspective of what do I need to do with respect to Proposition 65 and what are my next steps going forward. The most important point of Proposition 65 compliance, the starting point, is to identify which chemicals are present in your products. And to start off with, the way that plaintiffs approach this is that they are looking for exterior components that are visually identifiable that are likely to contain Proposition 65 listed chemicals. In this case, one of the most frequently litigated compounds is lead present in brass. Brass is in a variety of different products and it's visually identifiable. Also, phthalates in polyvinyl chloride or soft plastics, those are probably your most second highly litigated compounds, and those should be visually identifiable in a variety of different components. And as you go through it, and as Carol mentioned, that DEHP is identified in a number of these litigated products, and it's also both a carcinogen and a reproductive toxicant, which is why, as we go forward, that is often used as the basis for providing warnings for both endpoints. In addition, polycarbonate plastic may contain bisphenol A, which has been litigated to some degree, but not as frequently as the others. However, it is polycarbonate plastic is readily identifiable. Furthermore, there may be other types of components that are known to be present in a product. There may be electronic components that are known to contain flame retardants. There may be other types of finishes that are known to contain listed compounds such as VOCs like styrene, ethyl benzene, and so forth. Another category of products that are frequently litigated that typically contain lead but may contain other metals are foods from naturally occurring sources as well as processing. Some dietary supplements, lead is frequently litigated in dietary supplements, as well as cosmetics. The other place that one might want to look for the presence of listed chemicals information is in safety data sheets. That safety data sheets are required to identify federally identified hazardous substances in them, but only if they are at 1% or more, unless they are carcinogen, which is 0.1%. Those thresholds are relatively high as compared to the obligation to provide a warning or for purposes of Proposition 65. So if something is not present on a safety data sheet, it still may be present in a product or a chemical component at levels that are measurable and therefore might trigger a Proposition 65 notice of violation. The other place that information can be developed regarding the presence of chemicals is analytical data. And that analytical data may be supplied by upstream manufacturers or vendors, or it's something that you may be able to develop yourself in the context of Proposition 65 compliance audits. But the analytical data that you might be seeking as part of your indemnification agreements from upstream vendors may come in as a full materials disclosure and other related information. And then the last piece is there may be other sources of information about the presence of chemicals in different types of products that may be in the news or other sorts of technical journals or scientific journals. Next slide. The second step in looking at potential exposures to identify who may be exposed and how they might be exposed. That's going to be dependent upon what the product is and how it is used. It may be a consumer that's using a product, a cosmetic or some other material in or around the home where they're touching it, or it's degassing, or there's being transferred to their hand, or they may have some mouth-to-mouth contact with it. It may be in the context of a workplace exposure scenario where it's the chemical or product is on a tool, or it's on a building material, or just present in an office environment. Lastly, in this example, is it may be a mixture of these two types of exposures where someone is using a material, but it's much more similar to a workplace exposure than the ordinary consumer, where there might be less exposure to it, a do-it-yourselfer. And there is no limitation on how a person may be exposed to a product or a component containing a Proposition 65 chemical. There are many foreseeable and imaginable circumstances, but these are the three primary ones that are of concern for the types of products that I think that your organization is addressing. The next piece that we will want to look at is, how is one exposed to the chemical in the product or component? Is it skin contact, where it's transferred to the skin and may be absorbed through the skin? Or is it something that might be onto the skin and then subsequently transferred to the mouth, where it might be ingested? Or another alternative may be, it may be a volatile in a product that degasses and it moves into an indoor or outdoor area where it is inhaled. Or it can be a combination of all three of these routes of exposure, and that would need to be incorporated into the exposure assessment. Next slide. And the last step is, after we've identified the presence of a listed chemical in a product, looked at how somebody might be exposed to it, is to estimate how much exposure to that listed chemical can occur. It may be different for a consumer, it may be different for a worker, and it may be different for a do-it-yourselfer. And to the extent that one type of exposure results in a significant risk, there may be a duty to provide a warning in one context, but not another. And that has ramifications to what Carol was talking about previously, with providing warnings that satisfy the hazard communication standard to discharge that duty in a worker context. But because there may be less exposure for a consumer product to the average consumer, that no warning is necessary. So it becomes very important to tailor your exposure assessment to the individuals and the types of uses of that product. The first question you must ask to determine if you're above a significant risk level after you've estimated the exposure, is there a safe harbor level for the chemical of concern? There's approximately 300 of these identified that may be route-specific, inhalation, ingestion, or non-specific. If there is no value promulgated, then one would have to identify a cancer potency factor for carcinogens, or identify some studies for that particular chemical at which there is a no observed effect level, or a level below which there is no reproductive or developmental effect. And then based upon those, identify your own safe harbor level for purposes of comparison. Again, you may have to do that in some cases. And then lastly, you may end up having to generate your own cancer potency factor, or conduct your own studies, or do a very careful literature search and extrapolate from existing chemicals. The second bullet are your data needs. You're going to have to identify what sort of information do you need to perform your exposure assessment. Is it available in the literature where you can find it readily and apply it? Is there some other guidance out there? Can you adapt the Proposition 65 safe use determinations or interpretive guidelines as a means by which to estimate potential exposure? You may need to develop it by conducting your own analytical work, simulating the use of the product by the average consumer or worker. Carol and I have done that for a number of products where we handle the product, simulate its use, and measure the transfer onto the hands of the volunteers, and then subsequently estimate exposure. In doing both of these activities, it takes time and it costs money, and the costs and the time are going to vary with respect to, is it readily available or must one develop it yourself? And then again, in determining the exposure, trying to apply information and approaches that are already in the literature for ease and consistency with demonstrating that the exposure does not exceed a safe harbor level, does not pose a significant risk, and you're not doing something de novo that hasn't been approved either by a court or OHIA. Again, there's case law and consent judgments that might be helpful into identifying approaches or other guideposts for evaluating, is the exposure or content of my product reasonable, or what might the plaintiffs expect? And then the last piece again of this is to compare it with the safe harbor levels. For example, does the exposure exceed 0.5 micrograms per day for lead? And then in the context of doing this, is there opportunities to average the exposure based upon use if you are above these safe harbor levels on a single daily basis on the day that the product is used? And so there's a number of degrees of refinement and complexity that can be used in evaluating potential exposure, and that the degree that you need to apply is going to be consistent with the importance of demonstrating the exposure is below a bright line significant risk level, and that's going to vary from product to product and circumstance to circumstance. Next slide.
Thank you, Mike. Putting this all together as a summary, it really works best if the entire company integrates the requirements of Proposition 65 into its day-to-day operations. Mike and I have assisted companies to do this for over 20 years. The cost is not high, and not everyone needs an outside counsel or even an exposure assessor to assist them in this. This is something that can really be done by your regulatory folks, but it will require pulling together the various components, the R&D, the purchasing, the sales folks, in order to have them understand the concept of how to evaluate the materials they purchase, and to make sure you're buying the components that you need to make the products that are not going to have the propensity to add listed chemicals to your product and pose liability. So understanding where the chemicals come from, understanding the audit that you can do yourself. I'll point this out. When I started with Proposition 65, I was working as the environmental manager for Rockwell International. This was even before I became a lawyer. It was like shortly after the regulations were adopted, and just taking the regulations and the requirements and talking to the state agencies, I was tasked with putting together a compliance program for a major aerospace company with hundreds of thousands of employees. It was not that difficult. We were able to do it, but it took the teamwork of talking to quality, talking to purchasing, talking to various customer liaisons about the product. So it can be done. It's not beyond the pale, and it can be done and integrated into your operations plan pretty easily. But it does take a person that's tasked, and it takes some real effort, and it takes supportive management in order to make sure that the resources of the company are focused on this. You should probably be able to get this done and integrated in less than 90 days, provided that a commitment is made to really pay attention to this. So giving you a little personal anecdote to let you know this isn't a sales pitch for going out and hiring a law firm and an outside consultant. On the other hand, you may need those resources, and if so, we're here to help you should you determine that you wish to get some consulting on this. But it needs to be done. Putting it all together will not happen unless there is the will of the company to evaluate compliance and to make sure that you're doing it all right. So with the next slide, please. So with all of this, I know there's lots of questions, and Mike and I are here to try to answer those that we can. We're going to keep on the line for at least the next 20 minutes or until there are no more questions. Liz, do you have questions for us?
Oh, we have lots of questions. Thank you all very much for your attention and for your participation here. The first question we have is, if the sales are not to consumers and the customers do not ask, are distributor members required to provide the Prop 65 warning?
The answer to that is it's a best practice, and it can be done pretty easily. Put it on your SDS sheet. If it's not to consumers, then it is likely being sold to a customer who is a manufacturer of something else or is going to be distributing it in commerce. Under federal law, the SDS does not require disclosure of Proposition 65 listed chemicals at all. If those chemicals, Proposition 65 listed chemicals, are on a national list, of which I would say 80% of them, maybe more, are on a national disclosure list, the trigger level for requiring notification are quite high. I mean, it's like 0.1 ppm. Under Proposition 65, the trigger level for a warning can be at the level of detection. So what we recommend is, if you know that your product contains a Proposition 65 listed chemical and it is there at a contaminant level, that you take advantage of Section 15. Section 15 is other information. You can disclose that information on Section 15 by merely putting the warning there for Proposition 65 and identifying the chemicals that may be in there as a contaminant, so that your customer actually knows that they're there and can take that into consideration when they use the materials you sell to them.
Great.
I hope that answers the question. That's a complex question that oftentimes is nuanced in that it requires a lot of specific facts to drill down, but that's the general advice we always give. Liz, another question?
Yes, it's a very similar question. If a distributor sells material to fabricators who would then go on to do some kind of value-added shaping or machining to the material, what are they required to supply? what are the distributors required to supply to the fabricators regarding Prop 65?
Well, again, if you're out of state, if you are in state, if you were in California, you are required to incorporate into your SDS, because it's going to be, you're going to have to supply the SDS in accordance with California law, not the rest of the world's law. But assuming you're out of state or out of country, there are global treaties that harmonize how these reportings are done on SDSs. And again, you can provide the California information in Section 15, and you really ought to do it. Because if you do that, you have provided notification to that fabricator, and that notification allows him to make the kind of decisions he needs when he then turns and sells his value added or his product to the next person in line. And you have fulfilled your requirements. If you are a fabricator and you get an SDS for a material and notice it has Proposition 65, pick up the phone and call your material supplier and find out as much information as you can. It may be that the notification is sufficient and you don't have any concern, but the dialogue between the parties is always the best course of action. I've seen this happen literally hundreds of times. It does not mean that if you're the supplier, it does not mean that the customer is going to not do business with you. Usually they're quite happy that you're just having this dialogue, because it helps them make plans and to make sure when they sell the product that they've fabricated that they don't have any problems in passing it on up the stream. So,
okay, great.
Same answer, more detail, a pitch for communication. Next question.
Yes, this one might be more for Mike. The question is, how does encapsulation play into labeling requirements? And they give the examples of formaldehyde gas or carbon black.
Okay, let's start with carbon black. It is listed based upon, I believe it's a unbound carbon black of respirable size. And so unless that carbon black is being released or through the use of the product in some way where it's unbound in respirable size, the presence of it being in an article as a colorant or other purpose, I don't think would satisfy the listing requirement for it. With respect to formaldehyde, is that formaldehyde is a gas. Again, it's identified as formaldehyde gas, and therefore, unless there's exposure to the formaldehyde gas, it's questionable whether or not you would have to worry about that type of product with it being present. However, with that being said, if there's any possibility of using that product in which the formaldehyde is released and to a gaseous state where somebody can inhale it, then there's an exposure, and that would trigger the duty to provide a warning if the exposure exceeds the significant risk level. Carol, is there anything that you would add to that?
I would like to add a little to that. Boy, formaldehyde has been the subject of a lot of litigation. One example that I'm going to dwell on is the Lumber Liquidators case. In that case, formaldehyde is known to be in the glue of composites, and it is subject to regulation under the Clean Air Act in California, but it also is under Proposition 65. So even though the formaldehyde present in the glue in the Lumber Liquidators sold the floor tiles that you use on floors, there was detectable levels of formaldehyde outgassing, and this was subject of actually went to trial, and never got to determining whether there was a level that required a warning, because lumber liquidators put signs up on everything saying every piece of composite wood that we make and sell in this store will expose you to formaldehyde and wood dust and all, a lot of other things. So you need to be careful when you do these exposure assessments to identify, as Mike said, how this formaldehyde containing item is going to get into a product. The fact that something is encapsulated, you need to make sure that it stays encapsulated. In terms of carbon black, Mike is right. It is only listed if it's of respirable size. But if you sell something that contains carbon black in it, like a plastic pipe that has carbon, I know this probably doesn't even occur, I'm just making this up. A piece of pipe that has carbon black included in it to give it black color, and you know that when someone may cut that, or they may saw that, or they may in some way drill into that, if at that point carbon black is released in a respirable size, you may find that it is subject to litigation. So that's probably just an off-the-shelf or off-the-cuff example, but we have had an awfully lot of litigation for things like saws and drills, into plastic, into wood, into drywall. All of those things are argued that they release things that you would normally think were encapsulated. So care needs to be taken.
All right. Okay, thank you very much. The next question is, if you use the text warning with a hyperlink, what should you link to? The Prop 65 website or a long form warning?
Well, I think I need a little more context, but if you use the long form warning on a label, there is a www.proposition65.com. So that is what you link to. That is what the consumer would go to. If you put this on a website, where a hyperlink obviously would be the case when you give the warning, hyperlink has to be to OEA's website, www.com. And you can put that into your own browser, and you can go there even today. And you'll see what that is a long menu of information depending upon different kinds of products. So all you need to do is hyperlink to the www.proposition.com, 65.com, that is expressly given in the warning text. I hope that answers the question.
All right. Okay, so the next one is, as an indirect supplier, could we offer Prop 65 declarations as opposed to deliver warning through SDS? If so, are we only responsible to provide the declaration upon request by purchase order contract?
First, I would always caution against declarations. Perhaps I'm being too legal. A declaration is a statement made under penalty of perjury that certain facts are correct. You don't want to do that. There's always errors, mistakes, and things. However, a certification oftentimes companies will say, we have tested, and it is our opinion that this does not contain such and such a chemical, and that is worded in a way that you can sign that, and it's not stated under penalty of perjury. It's just your business is certifying it. So yes, you can provide a certification, And yes, you do not have to give it unsolicited. You can wait until your customer comes back and asks for it. So I hope that answers the question. It may, however, be that the customer is asking you to execute an indemnity statement that says if they get sued because of using your product in whatever they do, that you will accept the defense and you will, pay to have them, get out of the lawsuit, some kind of indemnity. That is probably not, unless the vendor accepts the certification in lieu of allowing you to sign the indemnity. Those are kind of two different things. I hope that answers the question.
Okay. Now, you might have already answered this one, but it's a slightly different way of looking at it. The question is, we supply only plastic raw materials that can be machined into parts for anything, but normally not for consumer products. Do we have to label our sheet and rod?
You do not, if you're not in California, you do not need to label your sheets themselves. Again, this is the sort of thing that you might provide the information. It's best practices to provide the information on the SDSs that are shipped with the first shipment to every customer. And that would be in section 15 again.
Okay. So as a manufacturer of stock-shaped plastics, how are we as a company supposed to determine the exposure level of finished goods that go through additional finishing processes before going to a potential customer?
Well, I'm going to throw part of this to Mike, but we need to know what the finishing processes are. Suppose you provide, tubing or elbow joints, or, if the finishing is only cutting them to length and or putting them in packages, that is going to be different than if you're providing a material that is then shaped and the end use is going to be completely controlled by the next person down the line. But assuming that you make a stock shape that is just cut, then I think the question becomes, what is that stock shape possibly going to be used for? Is it going to be used for plumbing in a home? Is it going to be used for irrigation? Is it, and you probably know what possible uses your customer is going to make. And again, these are things that you would probably put down what is likely to come out on your section 15. Mike, would you like to take we've done a lot of work for some of our plastics folks that have concerns about different kinds of things being in their products. Would you like to take a shot at fleshing this out a bit?
I agree with you that we would need to have a little bit more data about the size of the product and what you believe might be in it and how it might be used. For example, the chemical of concern might be styrene or some other volatile, and the part that's being made is very, very small, such the possibility that there's sufficient chemical remaining in it, and coupled with its use, that it would be impossible for an individual, or implausible rather, for someone to be exposed above a significant risk level, let alone to be likely to be measured by a plaintiff in an enforcement activity. That's to be contrasted with, let's say, something that's very, very large, a sheet of plastic or material that's a building product that may have materials that might be emitted at very high levels, be present in some location where it'd be very easy to determine that exposure might be above the significance level and readily detectable. In that case, you might want to consider putting a warning label on it or addressing it through an SDS, so that there is some sort of context that's necessary to consider on how you handle products that may have a variety of uses and that cannot be readily foreseen to a high degree of certainty. Is that fair, Carol?
Yes, I think so. And again, these are the kinds of questions we get from companies that have specific materials, specific kinds of uses, and we try to answer them in context. It's really hard to give a general answer to something like this. I think we've done about as well as we can.
All right. Do you have time for one more?
One more.
All right.
Make it the hardest one.
So we have questions from companies in California. So for distributors who are located in California but do not sell to customers, are they obligated to label their products and provide warnings as a direct party?
That is a hard one. Normally, a distributor who sells and distributes the products of others relies on the SDSs that are provided by the manufacturer. So if the manufacturer is outside California, the SDS that governs is the one that applies in the state or nation where that manufacturer puts the products in commerce. The distributor in California should have that SDS and pass it along when they distribute that product, whether it's in California or to someone out of the state. A distributor is not required to make an SDS or to provide warnings unless they do not get the information from the manufacturer. So I hope that answers the question. If the manufacturer of the product that the distributor in California distributes is located in California, that manufacturer in California is required to incorporate Proposition 65 labeling to the extent it's required, and Proposition 65 in SDS itself. So again, SDSs for industrial use product are the way to solve these problems. And what law applies is where the manufacturer puts those products in the stream of commerce. Hope that answers the question.
All right. Well, thank you very much. I'm sorry for the questions that we did not get time to answer. We will look at other ways of trying to address these questions and getting the information out to you all. This concludes our presentation. As a reminder, you will receive a survey. Once you complete the survey, there will be a link to download the presentation slides, and in a separate email, you will also receive a recording of today's presentation. We'd also like to remind you to mark your calendars and plan to attend one of our upcoming webinars, such as Distributor Analytics, So What, on Friday, September 21st. Thank you, Carol and Mike. Thank you all for joining us today. We really appreciate it. Have a great afternoon.
Thank you.
Thank you.